It's scary to put your or your family's future in the hands of a judge. When their ruling isn't in your favor, it's even scarier. You're probably watching this because you or someone you know is in this position right now, and you're wondering if there's anything you can do. Many family law decisions can be appealed. During the next few minutes, I'm going to discuss what the appeals process is like and whether or not an appeal is right for you. In Colorado, pretty much anything that was a disputed issue in the trial court and was reserved as an issue can be appealed. Some of the more common things that you might think about are property division orders, custody matters, or even maintenance. If you feel that something was off or that something may not have happened correctly in your case, think a calculation for child support maybe was incorrect, or a piece of evidence that you offered wasn't considered by the judge. The best piece of advice that I can give you is to have an experienced appeals attorney review the entire file, including the transcript if you have it, so we can talk about what options you might have and what might be available as far as appeal. People often ask me how soon should they file an appeal. The simple answer to that is as soon as possible. So the biggest thing to remember is that depending on the circumstances surrounding when and who issued your orders at the trial court level, your window of time for an appeal changes dramatically. So you could have as short of a window as 14 days up to potentially 49 days for that appeal process to start. So the biggest piece to remember is as soon as possible after you get those orders, come speak with an attorney on the appeal options to make sure that we can identify the correct procedure and the appropriate standards in order to reserve your issues. Once we are ready to proceed with the appeal process, just remember that it is a long and arduous road ahead of you. There are many steps, including notices, designation of records, briefs, potential oral arguments, and then, of course, you have to realize that if you win in an appeal, it doesn't automatically change the trial court's decision. 9 times out of 10, what's going to happen is it's going to go back to the trial court level to either potentially have a new trial on that particular issue with findings, or even allow the judge to revise its own findings to give the detail that was previously missing. So just remember, there's a lot of steps, it takes a lot of time. Speak with your attorney as soon as possible so we can identify what to expect, and then you are not taken by surprise on this process. Lastly, when you're considering an appeal, it's important to weigh the risk versus the reward in that action. Have a candid conversation with your attorney about not only the monetary investment that's going to be required, but also the time that this procedure is going to take. What you need to remember is that although an appeal may be an option, it may not be your only option. So let's talk about what other post-decree remedies might be available. Every situation is different. If you're considering appealing a family court ruling, set up a free case assessment and let's talk about your options.